by the order impugned.
Nine.
None appears for the petitioner at the time of call. No accommodation. Yes.
My lord, in item number 40, my lord, I am appearing for the petitioner, my lord. My lord, I'm seeking an accommodation for today, my lord, because my clerk has stuck in the rain and he has not brought the brief, my lord. Although I have the soft copy in my mobile, if my lord,
Then you can start. Yes.
my lord, the impugned order is quite striking, my lord, because my lord, if it comes to the impugned order over there, my order 6 rule 17 application was rejected, my lord. On the even without taking on consideration the written objections which were to be filed by the defendant. A date was fixed by the London Trial Court wherein the written objection was invited to be filed. On that particular day, the written objection was not forthcoming and the matter was suo motu heard. Both of us, that is the plaintiffs and defendants, we were under the impression that the matter will not be heard, because obviously if a date is fixed for written objection, for filing of written objection, and on that day if the written objection is not filed, the next day supposedly the other side, that is the defendant, will take time to file the written objection. No written objection was filed, my lord. We are the substituted plaintiffs, my lord, in the original suit. The original suit was filed by our father, my lord. Over there, my lord, during the course of the hearing, during the course of the suit, we found out that the scheduled property, in the scheduled property, my lord, the father of the plaintiffs or the petitioners, they had pleaded, my lord, that it was succeeded by him from his predecessor in interest. But in reality, it was purchased, my lord. And those deeds, the deeds from which they were purchased, they are also annexed with my petition, my lord. They are Kobala deeds. The translated copy is also annexed there.
Where is the plaint? Which page?
My lord, there has been an amendment beforehand, my lord. And the amended plaint is Annexure A, my lord, starting from page number 26. Lord may see kindly the CS Khotiar number in paragraph number 1. It is written in the amended plaint. That is, my lord, to kindly come to page number 27, my lord. The CS Khotiar number is written 291. It is an admitted fact. In the schedule, it is written typographical error is there 191. And we had sought this amendment in our amendment application. The schedule of our amendment application says CS Khotiar number 291. The learned trial court says that the entire nature and character of the suit is going to change if this is allowed. This is an admitted position of fact. My lord, the schedule of the plaint is at page number 32, my lord. The CS Khotiar number is appearing over there 191. The original Khotiar number, CS Khotiar number is 291, admitted position. These are the amendments which we were seeking.
What are the amendments?
My lord, the amendment first, my lord, we come to the schedule of amendment, which I had also put out in my
Page 41. Page 41 is the
yes,
schedule.
I have also set out the schedule of amendment in my divisional application also, my lord.
No, in page 41 is the schedule of amendment.
Yes.
This is contrary to the original pleading.
My lord, may kindly come to the schedule. The schedule,
Yes.
the schedule in the schedule of amendment.
Yes.
My lord, over there, my lord may see that CS Khotiar number is written 291.
Yes.
Yes. My lord may now come to the amended plaint paragraph number 1.
Amended plaint.
Yes. My lord may, because
how could you file the amended plaint without the
amendment had happened once. It was prior. We had also, there was also a civil revisional application which my lord had disposed of. It had appeared from this suit only earlier.
Where is the amended plaint?
Amended plaint is appearing at page number 32, my lord. Annexure A.
Yes.
Sorry, page number 26, my lord. Annexure A. My lord may come to paragraph number 1 at page number 27, my lord.
Yes.
My lord, the property comprised within the CS DAG numbers 99, 100, 107, 108 appertaining to CS Khotiar number 291.
Yes.
My lord, may now come to the schedule of amendment. We are seeking 291. It is in place of 191. We are seeking 291.
It is 191. 191 is the
Yes, my lord. The amended plaints, schedule may kindly come to amendment plaints schedule, my lord. It is page number 32, my lord. Come. Yes,
32.
In paragraph number 1, it is written 291. In the schedule of the amended plaint, it is written 191. In paragraph number, in page number 32.
But you have not sought for correction of that.
Yes, we have.
Show me from the schedule you have wanted to correct the body of the application.
Yes,
paragraph 1, 2, 3. You have not sought for correction of the only the schedule. Also the
yes, also with regard to paragraph number 1, 2, 3. Now,
yes.
what is paragraph number 1, 2, 3? In paragraph number 1, 2, 3, we have stated that we have got this property on an intestate succession basis from our predecessor, that is the plaintiff's father. Now, whereas the reality is that the plaintiff had purchased this property with regard to 2 Kobala deeds, which we had also brought on record.
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
The order dated 8 of 8 of May 2025 is under challenge before your lordship, my lord. The case of the petitioner is, my lord, the petitioner has made an application for dismissal of the suit filed by the opposite party, my lord, that has been rejected by the learned court below, my lord.
Order 7, Rule 11.
It is not nomenclature in the same way, but it is in the nature of the order 7 rule 11, my lord.
Yes. What is your ground in the
My lord,
application?
kindly come to the plaint filed by the opposite party, my lord.
Yes.
The prayer portion type copy page 65, my lord. The opposite party plaintiff has challenged in this suit a decree which has been passed in the title suit number 7 of 1991 in 1994, my lord. And the most importantly, my lord, the plaintiff opposite party was not a party in the suit of title suit number 7 of 1991, my lord. The case of the petitioner is that, my lord, the father of the petitioner.
Where is your application? Where is your application?
My application is, my lord, H page number 122.
122.
My lord. The division bench of this honorable court has also expressed his opinion regarding the validity of the decree passed in title suit number 7 of 1991, my lord. That is at page number 118. My father have executed a lease to one Rasulan BV, my lord, in the year 1957 that was valid for 10 years, and thereafter the said lease expired, my lord. Thereafter in 1991, B, the petitioner along with his sister filed a suit for declaration and permanent injunction, my lord. That the suit was decreed in my favor in 1994, my lord. The petitioner herein, the plaintiff herein, my lord, have challenged the decree passed in 1994 in which he was not a party, and after 15 years of the passing of the decree, my lord, on the ground that he is the legal heir of Rasulan BB, my lord.
What is the stage of the suit?
Suit is for framing of the issue, my lord, only. And kindly come to the page number 118 and 19, my lord. 118 and 19. The observation made by the Honorable Division Bench of this Honorable Court regarding the validity of the title decree passed in the title suit number 7 of 1991, my lord. Third paragraph of the page number 108, my lord. And second paragraph of 119, my lord, and onward. In which the opposite party has been the party, my lord. He is claiming to be a Thika talent on the basis of being a legal heir of Rasulan BB, my lord. His claim has been rejected by the Division Bench of this Honorable Court, my lord, by an order dated 4th of July 2022. He is no more a Thika tenant, my lord. So the extent suit is just wastage of the judicial hour, my lord. Kindly come to the page number 119. The decree passed by the civil court during the the second paragraph, my lord. Between the period when the act of so and so is.
Rasulan Bibi was the party in the suit of 7 of 1991.
And he had no challenge the order, judgment, my
You
lord.
are appearing.
The present plaintiff was not party in that suit. All these judgments have been brought to the notice of the Honorable Learned Singh Court below, my lord. In spite of the fact, in spite of that, my application has been rejected.
Yes, Mr. Haldar.
But admittedly, my lord, the property is a Thika property. Initially, my lord,
Who are you?
I am a Thika tenant in respect of the suit property. They are the superior landlord, Jomindar. They are the Jomindar. Mal after 1981 Act, this property has been vested to the state of West Bengal. What they did, in 1991, they filed a suit against the Rasulan Bibi. The Rasulan Bibi was recorded as a Thika tenant in respect of the suit property. In 1991, they filed a suit claiming absolute right title interest over the property in question. That was decreed ex parte, my lord. Subsequently, I being the heirs of the said Rasulan Bibi, I challenge that decree in the instant suit. This, my lord, 49 of 2000, this suit.
Yes. Yes.
49 of 2009. My lord, admittedly, the property is a Thika property, my lord. Their contention is that, my lord, after the vesting of the instant property, my lord, the Rasulun, my lord, has not, my lord, submitted any return, my lord. So his name, as recorded as a Thika tenant, is, my lord, is void, is illegal. Anyhow, my lord, during pendency of the instant proceeding, my lord, they, my lord, challenged the order of the Thika controller before the learned tribunal.
Thika controller passed what order?
The Thika controller, my lord, recorded the name of the
Recorded the
present
name,
plaintiff as a Thika tenant in respect of the suit property. They challenged the said before the learned, my lord, tribunal. Learned tribunal, my lord, what did, my lord, since, my lord, this order was passed, my lord, only hearing my client without hearing their side.
I was present.
Their side, my lord, the matter was remanded back to the learned court below, before the learned Thika
Tribunal.
controller. They are
Controller.
challenging that they came up before this honorable court. This honorable court held, since in 1991 suit, my lord, they have been declared as a, my lord, absolute owner. Court has, my lord, overlooked this division bench because, my lord, they are claiming, my lord, they are superior landlord. Now they are claiming absolute ownership. Where is, my lord,
And the
from
Thika
their
tenant
statement,
has
my
been
lord,
set
they
aside,
declared
my
that property is a Thika property.
Mr. Haldar, I cannot go into, I cannot say that the Honorable Division Bench overlooked this matter.
And they have
My
not
lord,
challenged
because,
the division bench, my lord.
That cannot be said here.
But now, my lord, at this juncture, my lord, this is a suit of, my lord, 2009. My lord, this application for challenging maintainability of the suit, whether, my lord, this is a factual aspect, not any of the clauses as embodied in under Order 7 Rule 11.
First of all, who are you, sir? What is your locus?
My lord, that is to be decided if he has a merit over the case, my lord, he has to be proved, my lord. This is a
You
mixed
have
question.
filed your written statement.
I am the plaintiff.
Yes, my lord.
You have filed your
My
written
lord.
statement.
My lord. This is along annexed with the
But this decree, my lord, on the face of it, my lord,
and
expeditious
on the
that is,
basis
my
of
lord,
the
also
pendency
not
of the
tenable.
suit, my lord, I
Because
am
the
unable
property-
to enter into my property, my lord. They are in the possession of the suit property, my lord. On the ground that title suit number 49 is pending.
Title suit number?
49
Yes.
is pending. After
Yes.
passing of the division bench order, my lord, they are not handing over the property, my lord. They are in possession of that, my lord. That
No, the Honorable Division Bench did not direct the handing over of possession. Where is that?
Thika is already set aside, my lord. Recording of the Thika is already set aside. They are no come to the page number 121. The impugned order,
Any order of injunction has been passed in the suit.
the order of Thika controller is also set aside. He no Thika tenant anymore. They have he has contested.
Where is the decree passed in the suit of 1991?
My lord, kindly come to page number 85. Relevant portion is at page number 86, my lord. Hence ordered that the suit be and the same is decreed expertise with cost against the defendant. Defendant is the Raslan BB, my lord. He is hereby declared that the plaintiff and the performer defendant number 2 and 3, who are the defendant number 2 and 3 in the stand, 3 and 4 in the stand, no, 2 and 3 in the stand suit, has expired already, my lord. I am the only surviving defendant in the suit, my lord. Are the absolute and inclusive owner and occupier in respect of the suit property. Page number 86, my lord. The plaintiff, that is the your petitioner, my lord. The plaintiff do get a decree for mandatory injunction against the defendant number 4, who is directed to remove the names of the defendant number 1 from the office record of the defendant within 2 months from the date. And the name was already removed. The name of Rasman will be removed from the record of the corporation, my lord. And the most important, my lord, the Rasman BB was issueless. The plaintiff is not a legal heir of the Raslan BB, my lord.
That cannot be decided here. That cannot be decided here. I'm expediting the suit. I'm directing the issues to be framed and the suit to be expedited.
My lord, already everything has been decided, my lord. He is not a Thika tenant, my lord.
This application under Article
কি করে পৌঁছে যেতাম না এতক্ষণে না আছে না বলুন ই গেট দিয়ে এসে ফার্স্ট ফ্লোরে চলে আসুন 4 নম্বর গেটের সামনে 4 নম্বর কোর্টের সামনে ঠিক আছে ই গেট দিয়ে you have to make the entry you have to get a gate pass from there get the gate pass you wait over there my person would contact you immediately ঠিক আছে wait in yes yes
However, made clear,
One thing,
it is however made clear that all call the next matter.
It is the suit of the
one thing, they are superior landlord. After the order of vesting, they cannot claim absolute ownership of the property.
Take all the point. Yes, yes, call the next matter.
My lord, Mr. Owen Kumar Bodal is appearing for the opposite party.
I am for the opposite parties number 1 2 and 3 my lord
Yes.
Kindly see that it is on my instance that a proceeding under section 218 was initiated. I filed a writ petition before the coordinate bench of this honorable court. Ultimately, in the writ petition that I have annexed, in the writ petition, there is an exercise done by the coordinate bench that a special officer appointed is submitted a report wherein the illegal construction has been evident. This honorable court directed the 218 proceeding to be drawn up by the municipality, dispose of my writ petition. Thereafter, the 200 proceeding has been drawn up, wherein I submitted my written argument. An elaborate order under section 218 for self-demolition has been passed by the competent authority, Board of Council. Challenging that, they have preferred the regular 218(3) appeal before the civil judge, wherein my lord I lodge caveat. Kindly now look, takes up my lord the order impugned. The learned judge recorded that I have lodged caveat, but my lord passed an order without insisting my lord the plaintiff my lord to serve a copy of the my lord application my lord upon the my lord caveator. But your lordship, my lord, this is my lord something is my lord the propriety of the court. My lord, I lodged a caveat. My lord, it is me on my instance the entirety of the proceeding has been initiated. I approached this honorable court. I was there before the 218 proceeding when my lord hearing was took place. My lord, it is I lodge caveat court. My lord, it is the duty of the court to ensure that the copy of the my lord application should be served upon my lord learned advocate who lodged the caveat. My lord, without insisting on that, my lord, the order has been passed since as if the municipality is the actual party against whom the order has been sought for. So no necessity my lord, for serving of copy to the my lord, caveator who is also a party to the proceeding. Lodge caveat. My lord, your lordship knows, my lord, this judgment, my lord, has taken care of my lord, the division bench judgment of this honorable court. Kindly looks up my lord, paragraph 34 onwards. This similar issue, my lord, cropped up there also.
My lord, a copy of the judgment may be handed over to my advocate on record, my lord.
Already handled. The deed is
The whole difficulty, my lord, I am sorry, I am appearing from my car, my lord, as that entire North Calcutta has been locked down. The total jam-packed, this water logging.
Now, Mr. Mukherjee, I appreciate there is no dispute with regard to that no order of interim order can be passed.
my lord, I say I am ready, my lord, to
My lord.
participate for hearing even tomorrow. Even tomorrow. My lord, I know, my lord, what your lordship is my lord, proposing that if
So I'm directing
yes,
the appeal, miscellaneous appeal is ready for hearing.
yes.
So I'm
Yes, it's ready for hearing, my lord.
so I'm directing the miscellaneous appeal to be disposed.
And one is how Mr. Mukherjee's client is aggrieved by this order. It's an
Well,
order.
yes, sir, he has reasons to feel aggrieved. He has lodged the caveat. Why have you do
He
this?
has lost the caveat. It's fact. It's an admitted fact. But
Yes,
the
this is
executing
fact,
court
we-
of the order, special officer's order would be executed by the
Yes, yes.
municipality only, my lord.
He can be aggrieved. He has reasons to feel aggrieved. There was a caveat. You obtained an order of interim order without serving, or you are now saying why he has reasons to feel aggrieved.
Well,
Yes.
agreements by the order, the
Yes.
the opposite parties building would be demolished, my lord.
Yes, yes. That is neither here nor there. If the caveat was lodged, so that is a sufficient ground for vacating this order, setting
But
aside
this-
that order.
My lord,
Yes, the
What I
miscellaneous.
proposing, Lord, your lordship is directing Lord, the miscellaneous appeal itself to be heard out. What I proposing, Lord, kindly once looks at Lord, the first paragraph. The appellant stated, has your lordship got it, Lord? The
Yes.
appellant stated that the Honorable High Court in its order dated such and such directed municipal authority that the municipality shall consider the request the request of the demolition of the unauthorized construction. Further, the appellant stated that the municipality did not consider the revised plan. I have annexed the order, my lord. They have considered the revised plan and that has been turned down. Their prayer for consideration of the revised plan. The municipality is of the considered view that it is an as-made plan. There is no provision. And it is also beyond the rule.
That is
50.
on merits, Mr.
That's why
Mukherjee.
let this application, my lord, for stay be heard out once at my presence so that I can, my lord, also ventilate that grievance. For one day.
Application is pending, no?
Yes.
It has been disposed of.
application is pending, my lord.
That's why.
No. 151 is allowed.
But the directed the stay of execution of notice dated such and such till the next date. So, my lord, it's not that the till disposal of the
What is the next date?
next date, my lord,
My lord, 9th of September.
9th of September.
So I'm directing the stay application to be disposed of.
Yes.
And my lord, kindly make that remark, my lord, this is, my lord, something which should not have been done. The court should, my lord, exercise this, my lord, upon, my lord, ensuring the copy to be served upon the, my lord, caveator. This is, my lord, where the honorable division bench, my lord, in the given
So
case.
Mukherjee, whether the
Exactly.
provisions of section 148 capital A
Yes.
shall apply to a proceedings of this nature.
My lord, it is, my lord, akin. My lord, your lordship knows, my lord, when. My lord, it is a civil
It's
court.
a statutory,
But,
Mr.
my lord,
Mukherjee, it's a statutory appeal.
yes.
So whether the civil judge is functioning as a civil judge or an authority under that statute.
No, my lord, it is not an authority. Kindly see the language. It's the competent civil court who will have the determination, the jurisdiction. So, my lord, it is not a regular suit under section 9. But if, my lord, your lordship knows the central filing section, there are procedure. Even if your lordship is aware that section 18 the reference from the the reference that has been made that
But
acting as a
without going-
tribunal.
Without
Acting as a
going to
tribunal
that,
under the
I'm keeping this issue open, the applicability
I'm
of,
just,
I'm keeping this issue open because it may arise some, because this judgment
this
is not on,
something
this is not on,
central filing section.
that has to be
Had it been the
considered.
case that 148 if not being applicable, then the central filing section ought not to have allowed the lodging of caveat. Caveat lodged. Central filing section given a note that yes, there is a caveat.
That, Mr. Mukherjee, nobody knows before the civil court. Since civil court, you are lodging a caveat.
But
It is being,
this is something this
because
then this will be given a go by that.
it is also not a suit. It is a miscellaneous appeal.
Maybe, but
So,
a lodging of caveat, it's not restricted.
miscellaneous appeal, and before the, everything is vague with regard to this. Statute is vague, procedures are vague. Somewhere municipal miscellaneous appeal, somewhere only miscellaneous appeal, somewhere it's registered as a suit.
Other suit.
So
even that,
everything is vague
but
with regard to this.
the lodging of caveat is not being disputed. Why I rely upon the division bench? Division bench at the given facts set aside the order and remand the matter back.
Mr. Mukherjee, this is not an appeal under section 280.
It does
So
not.
that is with
change-
regard to a regular suit, regular proceedings.
But that does not change the texture of the proceeding. 148 lodging of caveat. It's a civil judge who is taking up the matter. He is taking a note that caveat has lodged.
This application under Article 220
huh? No, sir. বেরিয়ে যাচ্ছে
Status quo should be there, my lord.
I have not interfered with that. I have not set aside the impugned
But
order.
only one
Grateful,
thing,
man.
my lord, even I have served the municipality.
It is however made clear
I have
the
not-
affidavit of service. একদম উপরে লিখে দেবেন
But
on
I
the
think
prayer
most
of
of the-
Mr. Municipality has been served. Yes.
I said, my lord, he's saying he's coming, my lord.
All right. Call the next matter. Passover. Yes. No. What?
Lord, I am for the petition.
Yes.
There is a caveat, my lord, I have served.
Who is for the caveat?
My lord, Mr. Partho Pratim Mukhopadhyay.
Where is he?
My lord, by the order impugned my application, দেখ না ফোন করে পার্থটা কোথায়? By the order impugned, my application for local inspection is being turned down. My lord, the suit is for declaration and permanent injunction, wherein I have a counter claim. My lord, if your lordship takes up the plaint once, what is the scheduled property? My lord, page 16 of my lord's brief. As you
Yes.
my lord, kindly see, my lord, it's permanent declaration of their right title interest and permanent injunction restraining me, my lord, from disturbing his position. What is the schedule? 9 katha 6 chitaks be the same metal more or less together with a structure standing thereon with 8 feet wide common passage.
10 feet.
10 feet, sorry, 10 feet wide common passage with all easement. Now, my lord, what is, my lord, the boundary? North, my lord, kindly see this portion, north 91 by 1 Madhusudan Bishas Lane.
Yes.
But other part I am not coming, my lord, right now. If your lordship takes up, my lord, my counter claim, written statement come counter claim starts with page 27 of my lord's brief.
Yes. Yes.
My lord, page 33 is my prayer, but my lord, kindly see page 34 once. Has your
Yes.
lordship got it, my lord? That piece and parcel of land measuring 9 katha 6 chitaks together with a permanent structure as club room measuring about 1600 square feet more or less at the southern side and a club playground along with a mandir situated at the northern side of the same along with the common and easement right attached to. Now, my lord, if your lordship takes up on the north portion, my lord would get 1 by 1 Madhusudan Bishas Lane. So, my lord, this topography, I say, my lord, I am there. It is not a case, my lord, where I have also stated declaration of my right title interest and, my lord, permanent injunction so that they cannot disturb me. My lord, possession cannot be proved by virtue of, my lord, any, my lord, local inspection. I bow down before your lordship. But what is my application? Prior to hearing of the injunction, because there is a subsisting order of injunction restraining me, my lord, from disturbing his possession. Nevertheless, my lord, if your lordship takes up page 51 once, I never suggested that the possession to be proved by virtue of a local inspection. Kindly takes up the point of inspection as page 53. I say this exercise is.
Give me a minute.
Fine, I'm sorry. Instruction nahi daraba.
Yes.
Mr. Mukherjee Millard has informed now my junior Mr. Mukherjee that though he do not have instruction to appear in this matter, but he lodged caveat, he is coming.
Yes.
But I have page 53 once your lordship looks at whether my endeavor is to find out who is in possession, my lord, kindly consider that, my lord, point of inspection whether that is there. What I intend to bring the actual topography of the suit property, whether there is a existence of, my lord, club room, playground, mandir over the suit property, because that has not been described in the schedule of the plain. That has been mentioned in the schedule of the counterclaim. And exactly I have not stated that let this exercise be done comparing both the schedule.
Show me your pleadings.
Milord, in
Regard
the
to this.
Milord, in the
Counterclaim.
counterclaim. Milord, if your lordship takes up, Milord, my counterclaim starts page 27.
Yes.
Kindly takes up, Milord, Roman point number 3 at page 29 onwards.
So you are claiming the same property.
Same property, Milord. But I say what they have narrated, that is not the actual picture. There's a playground, there's a club room existence, there is a mandir over there.
Show me your prayers in the.
Yes, my lord, kindly
counterclaim.
takes up, my lord, counterclaim prayers at page 33 of my lord's brief. Kindly see prayer D also.
Yes, Mr. Mukherjee, this
Why, my lord?
declaration, whether
Why,
you
my
have
lord, I am
acquired
saying,
adverse possession,
why, my lord,
declaration, possession, all this can be proved by way
yes,
of
my lord, what I am, my lord, what I am, my lord,
not
today,
necessary.
my lord,
What
for
is
the
the
purpose,
declaration?
my lord,
What
I
will be
have,
done by
my
this?
lord, I have pleaded that Sheba Puja, all
Maybe
that,
you,
everything is,
Mr. Mukherjee, you may be doing that, but your prayer is that you have claimed adverse possession.
yes,
Succeed in the suit.
my lord, I will, my lord,
Prove your
for the
adverse
purpose of,
possession.
for the purpose of bringing the actual topography, because the
Not
club
necessary.
room existence, my lord,
Maybe.
it's something which, my lord, needs to be gone into, because, my lord, both the parties, what both the parties are saying, he is saying don't disturb my possession, I am saying no, I am in possession. Possession need not be, my lord, shown by virtue of local inspection, but at least the topography, what they have suggested, they have stated that on
An
the northern
indirect
side,
way of to prove
no, my lord,
possession.
on the northern side they stated, my lord, this is 90 by 1 Madhusudan Vishwas Lane. I have shown before your lordship that 90 by 1 is not the northern side according to the counterclaim, my lord. The northern
So
side is
prove
1
that.
by 1.
Prove
My
that.
lord, that, my lord, cannot be proved, my lord, without the
Also
local
not be local inspection.
local inspection, at
Cannot
least
be.
topography, at least, my lord, the fourth side of the, my lord,
Topography not necessary considering the pairs in the claim, in your counterclaim.
because, my lord,
What
this,
is the reasoning?
my lord, kindly see, reasoning is, my lord, the possession. I want to prove possession.
Absolutely right. This application under Article 2
I filed caveat, but no instruction, my lord. That is why I not.
You are appearing, Mr. Mukhopadhyay, I am disposing of this.
Yes.
I am only recording your presence. Acha.
No, 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 my lord. That's it, kindly
You
not.
have lodged the caveat. You have
No
been served.
instruction to appear, my lord.
You have lodged the caveat. You have instructions to appear. Ashun. The Mr.
Application for setting aside abatement, my lord.
application for
Setting aside abatement, my lord. Is
setting
pending,
aside abatement.
is pending since 1 year, my lord. Last 1 year, my lord. Kindly see the last
What is the
order
next date fixed for hearing of that
for
application?
July. My lord, that is 20.
30th of July.
Yes, my lord.
30th of July is for injunction application,
Yes.
not for setting aside
No,
abatement.
no, no. So I am saying that the Landlord court should be directed to dispose of miscase also on that date.
Miscase. What is the miscase for?
Setting aside abatement, my lord. That has been registered miscase, ma'am.
Cannot be disposed of on that date. It's the injunction. It has been fixed for injunction application.
Yes, my lord.
I am directing the injunction application. What is the miscellaneous? What is the main proceeding?
Main proceeding, my lord, suit, title suit, my lord, for declaration injunction, my lord, during the penitential suit, sold plaintiff died, my lord. For no substitution within time, my lord, that is the application.
Application under Article 227.
For my application for early disposal, my expeditious disposal, my lord.
Of what?
Of interlocutory application was a suit for partition of 2022, my lord.
Madhupur Court, do I have any
2012, my
difficulty in
lord.
taking up?
My lord.
Do I have any difficulty in taking up this matter?
On the now number of occasions they are taking time and matter is urgent. Oh, my lord.
Huh?
My lord.
You have any difficulty in taking up this matter?
I do not have any difficulty, my lord.
You may not have. I'm asking you whether I have any difficulty.
Yeah.
Have you inquired?
দেবাশিসদা আছে?
Mm,
দেবাশিসদা আছে নিচে?
no, 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 no,
Are
no,
you good?
no, no.
জেঠু নেই তো? মানে জেঠু মানে ওনার বাবা ছিলেন তো?
Yes. What is the petition which is pending for hearing on 4th of July 2025?
Substitution, my lord, date of defendant.
Substitution application.
Yes, my lord, they, along with 151 is also there. But what happened, my lord, 2012, my lord,
Unless the substitution application is decided,
that is, my lord,
this application under Article 227 of the Constitution. Yes.
I am for the petition.
Yes.
This application has been filed before your lordship, challenging the order passed by the learned court will on order 26 rule 9, the code of civil procedure. Kindly, I have filed a suit. We have filed a suit for declaration, right titling, interest recovery of possession, and removal of encroachment of the suit property. Now, thereafter, the learned court below was pleased to pass an interim order at page 40 on 2/9/2024. Over the portion is at page 42. The instance petition is for temporary.
Where is the plaint?
Plaint, my lord, at page 11, page 11, annexure A. Now, interim injunction order was passed, and thereafter filed an application for order 26 rule 9 for local investigation. That was rejected on the ground as mentioned in the order. The learned court below specifically
Where is the application?
application at page, my lord, 43, annexure D. Yes, my lord. Now here, in the schedule of point of investigation that was mentioned, on what point it should be investigated by the engaged commissioner. The learned court below did not consider my prayer on the ground that I have no sketch, Moja map and record of and deed of conveyance. I have inherited my.
How will you describe the portion encroached in the plaint? However, describe the portion encroached in the plane.
Schedule C, my lord.
Schedule C.
Page 17. Property measuring about 188 square feet. Jail number so and so.
Which portion? 188 square feet. Have you given any sketch map?
Sketch map I have annexed.
At?
Sketch map I have annexed at page.
No, sketch map
33.
is not a part of the plane.
33.
Sketch map is not a part of the plane.
No part of the plan, but it is subsequently filed. At page 33, my lord. It is filed by surveyor for lot number so and so, a registered surveyor. And on the basis of this sketch map, the property in question can be examined and a measurement may be taken, because I have filed recovery of possession.
In page 33, which is the encroached portion, where it has been mentioned? Encroached portion has not been said in this plan.
Encroached portion, my lord, kindly see middle portion of lot number 2430 and lot number 2433. That portion was encroached. Middle portion, highlighted portion. This is encroached.
Which portion?
Page 33, my lord.
Yes, which portion is the encroached portion? You have not mentioned anything.
Middle portion, your lordship, kindly see plot number, middle portion, plot number 2430 and 2433. Middle portion, it is marked.
Plot number P.
Lot number P. It is encroached.
But the points are vague. Which deed? You have not mentioned
The
anything.
deed I have inherited my property
Sir,
from my
you have said,
predecessor.
please kindly come to your points. To take the measurement of to ascertain whether the defendant have constructed structures or not. Illegal construction, no deed, nothing has been made.
No,
I have the deed. Where is your deed?
I have inherited my property
Then
from my
your
predecessor.
points are vague. You have said the deed of the defendant.
Deed of the defendant, but our property was inherited from my predecessor in interest.
Sir, maybe when you have said
There may be.
Sir, where is the particulars of the deed? There is no particulars of the deed.
I have no deed. I have inherited my property from my predecessor in interest. Therefore, it cannot be said that I have no
Yes, sir.
right title interest over the property.
Yes, sir. Prove your title. This application under Article 227 of the Constitution of India
Item 47, Your Lordship, this is my petition, Your Lordship, for expeditious disposal of an application, Your Lordship, filed under Section 36 of the Arbitration and Conciliation Act in a pending, Your Lordship, 34 application. This Section 34 application, Your Lordship, was filed in 2023, and thereafter, Your Lordship, we filed an application for stay of the arbitral award. That was also filed on 18th of October 2023. Now, Your Lordship,
It is pending.
that is pending. Now, in the meantime, if there is no stay, they have filed an execution application
Is
before the
that
Bombay
is
High Court.
IA1 of 2023.
That is IA1. Your Lordship, I am praying, Your Lordship, is the expeditious disposal of the IA1.
This application under Article 2,
My Lord, in this matter, my Lord, I am appearing for the pro forma defendant petitioner.
no relief has been claimed against you. How are you aggrieved, Mr.
Yes. This is how the fraud has been practiced.
What do you
But
want?
My Lord, I want preponement of injunction hearing. My property, my Lord, can you consider?
Mr. Rai, I appreciate that. What is the next date fixed?
November.
Mr. Rai, I cannot postpone it from here. I can give you liberty. I can give you liberty. You can apply for preponement.
Only one thing, my Lord, I realize how fraud has been
I
practiced.
appreciate that, but how can I prepone that?
Yeah, I
Even if
thought,
you, Mr. Rai, even if you serve, I
yes.
do not know the diary of the learned civil judge. It will be very difficult. I can give you liberty.
Expert order injunction.
Have you taken out any application under Order 39 Rule 4?
I filed my objection. I have already filed the objection.
I can direct that to be decided expeditiously I can give you liberty to prepone, but very difficult from here to prepone because I do not know the diary of the landed civil.
Well,
Very difficult, Mr. Rai.
I have been my property.
I appreciate everything, but how can I prepone that? I also appreciate it has been fixed in November. It's very difficult. I do not know the diary of the landed civil judge.
Expert additive order injunction is continuing 2024. Now, my lord, without serving me, pro forma defendant, there is a collision suit between the defendant number
No
one.
order has been passed against you. No order has
The
been
property. My lord, what happened, my lord? I am the owner of this.
paid pro forma.
This is the trick, my lord. My property. I have cancelled the agreement for sale on the basis of which defendant number one transfers certain property to the plaintiff. The plaintiff and the defendant number now in collision were placing us as a pro forma defendant and filed a suit and obtain an order status of property which belongs to me, belongs to us.
Where is the interim order of injunction?
Yes, my lord. Can you turn to
Order dated 8th of April.
8th of April 24. As soon as I came to know, I appeared. Next page.
Mr. Rai, this order does not affect you because it's the plaintiff and the principal defendant. There is no order of
Defendant I would like to maintain complete form of status quo in respect of the supervisory details as such. Principal defendant. Now, my lord,
Yes, you are not the principal defendant.
I bow down to your lordship, my lord. When this status quo is passed, my lord, you will find that I am able to go and do anything over there.
No relief, no order against you.
The
Rai,
property will, if your lordship can
that is a different thing. If the property belongs to you, but no order is there against you,
this order, my lord, if your lordship can maintain the status quo in form
not against you.
My lord, if today this order is placed before the authority who is there, my lord, police is, my lord, knows how this order has been implemented and what is the status of the parties. A developer and they are the who are the plaintiff, they are their subordinates. This is a suit has been filed. My lord, can you consider only one thing, my lord, can you turn to internal page 4 of the plaint? My lord will find everything. Paragraph 6 and 7.
Mr. Rai, what can be done? I can give you liberty to apply for preponement there. I think that will be better. Earlier, you can file. I will direct the learned judge to consider that.
And to only that and dispose.
Fixing a date, Mr. Rai, please consider what is under what pressure they are working. If preponement, I will direct to be considered, but fixing, do it within this time. It may be very difficult because I do not know the diary of the learned civil judge. Maybe also hard pressed.
I'm not.
That is why. That is the
That
only
is why I'm
difficulty.
asking for the-
Even if you serve, it may be difficult for me to prepone. For that, I am giving you liberty to apply for that.
And Malakal, only to that extent, my lord, because otherwise, my lord, this is something, my lord, a property will be 7 months after the sale, date has been fixed for hearing of the injunction application. That is to SRAT upon defendant number 1. He is not appearing. The injunction could not be taken up. I have filed my objection. There is no relief against me.
That is why I am saying
That
it's
is
not affecting you.
Then, my lord, I am in
It
soup.
is affecting you.
That is why I am in soup. The court is not taking up the injunction application.
The pro forma dependents
The same. 52 probably by 4 revision application are same.
Why? Oh, why?
4 suits filed by 4 persons. Same.
49, 48, 49,
51.
50, 51, same order. একটু দেখে নেবেন শুধু সুট নাম্বারটা দেখে নেবেন।
Only suit
ঠিক আছে?
numbers are. Only, all others are same.
আর date is same, 4th of August,
Same.
4th of November,
Fourth, no,
and you are the pro forma defendant.
the property. We are the property.
Suit, same memorandum
Same.
of understanding.
Understanding. No. Same principal defendant.
Memorandum of understanding date is
Between-
different.
No. Between me and the defendant number 1 is the same.
No. In the plain, the memorandum of understanding date is there.
No.
Please check up and take that.
Say date below that. Those dates are different.
Those, তাহলে না, প্রিন্টে ক্লিয়ারে শুধু মেমোরান্ডাম। The next matter.
52, my lord, I am appearing for the petitioner.
Yes.
My lord, the execution case filed, my lord, 1995. A miss case started, my lord, in 2066. My lord, the court is adjourning matter, my lord. Kindly, my lord,
Miscellaneous case under what provision?
under section 47.
Section 47.
Seven.
So it's fixed for further argument on 17th.
Argument.
This application under article, you are the decree holder.
I am the
This
decree holder.
application.
The Lordship, I am in person. This order which has been, I am not challenging, but it's a modification because page number 10 and 11, it is my prayer. The page
Yes.
number
What
10
do you
and
want?
this modification of the order because the judgment which has been already given,
Modification of which order?
that order which I have annexed, that is
17th of March
17th
2025.
of March. Yes.
If you want
Lordship.
modification on what ground?
That is, your Lordship, this particular order which has been passed, because these trial suits which are pending for 13 years because it's a partition suit. And they are just lingering the process. And that's why, and because there is a judgment from the Honorable Division Bench High Court of 1966, which are also pending.
No, for on that ground, it cannot be recalled. So I can direct this suit to be disposed of expeditiously.
Lordship. And there is a, this is the judgment which, and
after some argument, the
Item number 54, my lord, I am appearing for the petitioner, my lord.
Yes.
Praying for my lord, expeditious disposal of the case, my lord.
Of what?
My lord, the partition suit was filed in 2020, my lord. My lord, since then, my lord.
What is the stage of the partition suit?
Partition suit, my lord, the stage of, it is running ex parte, my lord. The matter is ex parte.
This application under Article 2.
September, my lord. 2nd September.
Yes.
Get-
Yes, who is appearing in the next matter? None appears for the.
I have a small submission.
Yes,
That is item number 22. Of
not
today.
now. Yes, please, please. Next, call the next matter.
See, yes, my lord, in this matter, I am appearing for the petition.
Yes, Mr. Mukhopadhyay.
Well, petitioner before your lordship is, my lord.
22 Rule 10 allowed.
My lord,
Order 22 Rule 10 allowed.
order 22 rule 10 allowed in respect of
Mukhopadhyay, that's an appellable order. Order 43 Rule 1, I think T. You are challenging that order.
I am challenging, my lord.
You are challenging the order allowing order 22 Rule 10.
Yes, my
It's
lord.
an appellable order, Mr. Mukhopadhyay. Prefer an appeal.
Order dated 4th of April 2025, my lord.
L. Order dated?
4th of April 2025.
Yes. So by that, order 22 Rule 10 was allowed.
Order 22 rule 10 was allowed.
Yes. So it's an appellable order. By the order. Yes. Who is appearing? Passed over next.
58.
My lord, in this case, I am appealing on behalf of the petitioner, my lord.
Yes.
Lord, the rejection of 7.1 and 7.2.
Yes.
My lord, the ground is My lord, I did not receive the summon. That is a fact. Even in the order impugn, it has been mentioned that the summon has not been received. My lord, I have appeared that I have received information. I have appeared and filed the application, praying for direction to serve a copy of the plaint. My lord, the court has passed the order, directed me to serve a copy of the plaint. My lord, the copy was served after 10 to 15 days thereafter. My lord, immediately thereafter, I have filed sections 2 application under section 7 for depositing of rent. Court rejected my application on the ground.
So you appeared on 6th of February.
Yes, my lord, I know.
Did you file the application
Yes,
under
yes, my lord.
7172?
I have appeared on 6th February 2025.
Yes, when did you
My
file
lord,
this application?
the order was passed on direction to serve a copy of the plaint on 7th February 25. And
Sir, when did you
I'm yes, ma'am.
when did you file this
10th
application?
April 2025. 10th April.
Yes.
And my lord, the copy was served of the plaint on the 13th March 2025. The copy of the plaint was served to me. My lord, if my lord will kindly see page number 4, paragraph number 8. I have mentioned, my lord.
Where is the order sheet?
Yes, my lord. Impugn order, my lord.
No, not the impugn order. Show me that copy was.
Yes, my lord, I am showing. Well, I am showing. If my lord will kindly come to Annexure C, page number 21. There is a direction to serve a copy of the plaint to me.
Page?
Page number 21, my lord.
Page 21.
Yes, my lord. My lord, if my lord, accordingly, plaintiff is directed to serve a copy of the plaint upon the defendant in the meantime. Even if my lord will kindly see, my lord, in all the order, the summon has not been served. The court has directed to Order 5, Rule 20 to take appropriate steps. They have take appropriate steps, and I have appeared by filing appropriate application, my lord.
When the plaint was served?
Yes, my lord, I have mentioned in my application, my lord.
13th of March.
Yes, 13th of March, my lord. Page number 8, my paragraph number 8, page number 4, my lord.
And where is that order? You have placed that you were directed to serve a copy.
Yes, well, I am again seeing. Page number 21, if my lord will kindly. 21. Annexure C, my lord. The plaintiff is directed to serve a copy of the plaint upon the defendant, number 1, in the meantime.
The
Third bench.
till the end of the month of November 2025 or until further orders whichever is earlier. Call the next matter.
I'm grateful.
Contested application, monthly list of September. Yes, call the next matter.
9.
Yes, Mr. Chatterjee, this was the matter which you mentioned here.
জজের পেজ থেকে ইয়ে করছো তুমি তাহলে মেসেজ করতে যাচ্ছ
Yes, yes.
after
Caveator. After the disposal of that court, my lord, I am also agreed. My petition is being affirmed.
This matter.
Yes, that matter, my lord, 2 applications we shall file. Lord, all the 4 applications may be fixed on.
stay will be vacated.
No.
Yes, by the impugned.
No, impugned order, my lord, it has been struck down.
Yes.
Yes. Let us.
Lordship, on extension of interim order, it's expiring today, Your Lordship.
Where were you at the time in the
Pray for
morning?
apology, Your Lordship.
My lord, item number 22 of this.
22, what happened?
My lord, what happened that today's the atmosphere is very bad on the road because metros.
Where is your other side?
Uh,
Will appear tomorrow.
No. I served the copy.
Maybe please, it has been called on. You are not there. Somebody may be watching. I have kept it for tomorrow.
Not appear here.
I have kept it for tomorrow. You are also not present when the matter was called on. I have kept it for tomorrow.
Lordship, I pray for apology for mentioning now, Lordship. I should kind.
One. কি করছে Yes.
Not the second part of the order.
No.
Yes,
Page 174.
page 174. Yes.
যশোর কি ইয়ে করা আছে?
Mr. Banerjee, you are challenging you are seeking to challenge the last part of the order, both the orders. Yes, then what will happen?
No, the application for stay is considered disposal of contest by without cost.
Yes, 30th of September.
No, per month from August 2003.
First of such installment shall be deposited within 30th of June. Yes.
I'm aggrieved, sober my lord. I want to precise my argument. August 2003 to May 2025.
Yes.
This area.
Yes.
She filed an application for. It is not a suit decreed against me. I'm objector, filed my objection, and this miscase was registered on.
And Mr. Banerjee, what is your challenge that the rate should be increased? Occupation charges should be increased. Then Mr. Rai, when your applications are coming? When it will appear in the list? Wednesday. Then Mr. Banerjee, only one thing, because they are supposed to pay the first installment within 30th of June. So I have to stay that part for a limited period. Otherwise, Mr. Banerjee, it will become infructuous.
Earlier order was 4 lakh and 3 lakh. So the disposal of that application.
Yes.
Lordship further order was that without paying any party, you cannot be allowed to occupy the property.
But Mr. Banerjee, I have to.
Not if your lordship has paid this operation of this order.
Mr. Banerjee, till your matter is coming.
Lord, this will be amounting to Lord allowing the divisional application. This can be done only after the hearing of the parties.
Mr. Banerjee, Mr. Banerjee, I am not
suggesting that.
Then I will proceed on the basis of this application. I will proceed on the basis of this application. Your application has not yet come. Mr. Banerjee, your application has not yet come.
Say that entire order be a state.
Mr. Banerjee, I am saying only. Mr. Banerjee, I could not make myself clear. First installment is on 30. Is within 30th of June
2025.
So today is the last date.
Your lordship is not powerless to exchange after hearing. Your lordship is not powerless.
You don't execute. Then don't execute.
I undertake not to execute.
All right. Yes. That will do.
Your lordship thinks
That will do. If you say that you will give undertaking not to execute.
I shall not execute.
Yes. independently. So your matter I will take up on that date.
I follow.
That is why I have said till the,
I follow. I don't want to say.
I have kept the ball in your court.
Yes, Mr. Banerjee is there.
Yes, next.
60 kilometer map.
In this matter, you have not briefed Mr. Rai.
No, my lord.
Rejected.
কিসে reject? প্রথমেই বলে।
Yes.
Now, my lord, petitioner, my lord, challenges an order, my lord, whereby, my lord, the prayer of the petition, my lord, in the injunction in the form of a mandatory nature, in as much as, my lord, restraining, my lord, the defendants, my lord, from, my lord, causing any interference in raising a boundary wall, my lord, to my suit property. Now, my lord, what happened, my lord? The trial court, my lord, initially, my lord, the appeal court passed an order of injunction. My lord, High Court, my lord, in a civil revision, my lord, modified to the extent saying that there be a status quo till disposal of the entire injunction application. Trial court rejected the injunction application and my lord, misappellate court, my lord, allowed the injunction application, my lord, partly. My lord, if my lord takes up
The strategy, this matter is to be heard. Contest, injunction, contested hearing.
Yes,
At
yes,
this stage
contested.
also contested. I am keeping it under the heading contested application. There is no scope to pass any interim order, Mr. Chatterjee, at this.
No, my lord, I would say no interim order, but my lord, only thing, my lord, if I may say.
So I am fixing this under the heading here.
Lord, if for the moment, my lord, with regard to the main relief, my lord, ancillary, my lord, if my lord says, my lord, restraining them from entering, my lord, for the moment, interference with the wall, my lord, for the moment, finally, my lord, adjudicate.
Mr. Chatterjee, you are the plaintiff.
I'm the plaintiff. My lord, they are restrained from not causing nuisance. My lord, appeal court says, my lord,
Yes.
they are not agreed by that.
No, the status quo with regard to nature, character, title and possession.
Yes.
Both the
My lord,
parties are restrained from making any construction upon the changing the nature and
thereafter,
character
my lord, further the parties are directed not to create nuisance.
by throwing garbage.
So, my lord, entering, my lord, for them, they are entering into my property. Admittedly, this is my property. Well, that I will show. Well, that is contested. Well, that part is contested.
Which part?
Well, what they say, well, their predecessors sold, well, a portion of the property to me demarcated, single-handed owner.
No, what trial court dismissed that?
Yes, holding that I have a prima facie case, well, trial court dismissed the injunction. Appeal court modifies that. No, I have prima facie case. With balance of convenience.
Where is your injunction application?
My lord, my injunction application, if my lord takes up, my lord, page 36.
Page 36.
36.
This is the only prayer, Mr. Chatterjee.
Well, that can be.
No.
Well, then kindly fix it any day, my lord. Instead
of
of
Mr. Chatterjee, I can do one thing. I can expedite the suit. I think that's better.
No, my lord, what they are doing is, my lord,
because what
they
is the stage of the suit? Mr. Chatterjee, I think
injunction just disposed of.
Injunction, I can expedite the suit. Unnecessarily keeping this, what will happen? It's both the parties have been restrained because
if they now, my lord, problem is if they encroach, my lord, till now they
that
could
is not your allegation, Mr. Chatterjee, in the injunction application.
Yes,
So
they're
if
trying
there's
to
a further
encroach.
cause of action, you are at liberty to take steps. So from this, I think I am expediting the suit that will protect.
My lord, only one thing, my lord, kindly keeps it any day, my lord, my lord, as motion, my lord.
Not as motion. Not as motion, Mr. Chatterjee, it's difficult.
My lord, then, my lord, in the month of August, kindly keeps it contested application, I will come back.
By the
62, my lord, I appear on behalf of the petitioner.
Yes.
My lord, kindly, my lord, comes to page 49, my lord. On the earlier operation, your lordship had protected me, my lord. The operating part is at page 50, my lord. Para 6, my lord.
Yes, what happened to the
Yes.
section 5 application?
Yes, my lord, that is disposed of, my lord. My appeal has been admitted. Now, my lord, kindly, my lord, comes to
It has been admitted.
Yes, my lord. Now, my lord,
Other
kindly.
side has appeared.
Yes, my lord.
Yes, now what happened?
Now, my lord, kindly, my lord, comes to order number 6, the impugned order, my lord. Lord,
Yes.
Lord, kindly, my lord, sees the order, record is put up on the prayer, money receipt is filed showing payment of cost in view of the order of the honorable court passed in CO number such and such. This court finds it's not prudent to proceed with the stay application.
What happened to the earlier civil revision application?
My lord, that is still pending, my lord.
Interim order?
Interim order got vacated, my lord, but by efflux of time.
Interim order got vacated?
By efflux of time, my lord.
Yes.
But my lord, now, my lord, my appeal has been admitted and the next date fixed in the execution case is on 14th of July. But my lord, in the title appeal, the next date is fixed on 13th of November. My lord, unless my stay application is heard out, my lord, execution will proceed.
Yes, now what do you want?
My lord, only, my lord, so that the stay application may be heard before the London district judge, my lord.
I'm giving you liberty to apply for preponing. Now,
My lord,
what
I
is
have
the-
applied, my lord. I have applied, my lord, order
Where is
number
that
6.
other matter appearing?
It's in the monthly list, my lord.
Monthly list is appearing.
Monthly list is appearing.
So now, have you served a copy upon
Yes,
that?
my lord, that
Who is appearing?
I have got no intimation, my lord, who is appearing. My lord.
Nothing remains in the earlier.
Earlier revision, nothing remains.
What
my
is
lord.
the item number? Contested.
Lord, I'm checking, my lord, I'm checking.
আগেরটা বাদ করুন। So I'm giving you liberty to apply for preponement of the.
Lord, I have applied, my lord. The impugned order, kindly, my lord, sees the record is put up on the prayer, my lord. I have applied for preponing, my lord. But, my lord, the embargo remains that, my lord, your lordship's observation, my lord, that.
No, it was 18th of June.
Yes, 18th of June, the title appeal was adjourned in view of this order, my lord.
Why?
Because, my lord, kindly, my lord, sees page 50, my lord. My lord,
No, I have only. Stay has vacated.
Stay has vacated. My appeal has got admitted. But my lord, since your lordship had observed, my lord, only to take up the section 5 application, the London district judge is only has taken up only, my lord, the section 5 application, not the stay application.
It's very difficult. No, that was on put up petition.
Yes.
So according to you, the
I have
next date of title execution is on
14th of July.
What is the stage of the title execution?
Issuance of writ. Issuance of writ.
And what is the date of hearing of the stay application?
Title appeal, my lord, on 13th of November.
The application is on 13th of November.
No, my lord, since the London district judge observed, my lord, since your lordship has observed, my lord, for taking up section 5 application, my lord, it would be not prudent for him to take up the stay application.
All right. What is the item number of the other matter?
My lord, I'm checking.
This application under
63, my lord, I am appearing on behalf of the petitioner, my lord.
Yes.
The defendants, respondents herein, my lord, filed a title suit for declaration of their right title interest by virtue of the registered deed of gift, my lord. In the said suit, my lord, the petitioners who were the defendants before the learned court below did not file written statement within the statutory period. Therefore, the said suit was expert upon all respondents, my lord. In the meantime, my lord, the order under order 39 rule 1 and 2, the learned court will pass the injunction order, which was made absolute by the said order, my lord. But for implementation of the said, that's the defendants filed police help before the Domjur police stations before, with a prayer for implementing the said order. My lord, I have filed this CO challenging the impugned order number 16 dated 24th January 2025. My lord, I have filed the vacating application before the learned court below, my lord, which is still pending, my lord.
Yes, so long the vacating application is pending, this order cannot be interfered with. If
Yes.
it's vacated, this order will automatically go.
Yes, my lord.
So till that you cannot violate the order of injunction. This
My lord,
application under
the-
Article
64, I am for the petitioner, my lord. The petitioner, my lord, come before your lordship for expeditiously disposal of the, my lord, order 39, rule 1 and 2, and my lord, the proceedings, my lord. The suit for declaration and partition, permanent injunction in respect that suit was initiated, my lord, respondent number 1, my lord, he has obtained a, I am, my lord, the respondent, my lord. I am the defendant of the suit, my lord.
Which defendant?
Defendant number, my lord, 1 and 2.
Defendant number 4 has died.
Defendant number 4 has died.
So
my
how
lord.
can an order be
This,
passed at this stage?
my lord,
This
my lord, the,
application-
my lord, the problem is, my lord, the suit was filed on 23rd February 2022. Despite the knowing, my lord, the lords.
Yes, next.
Lordship, in this matter, item number 65, Your Lordship, I am in this matter appearing on behalf of the petitioner and I am being led by Mr. Odin Chakraborty. He is engaged in another court. I am praying for not today only not today.
No, not to the business, sir. It will go out of the business. Please proceed.
Your Lordship, I do not have the brief itself, Your Lordship. The brief is lying with my senior. Your Lordship, I am praying for short Passover then.
Yes. Yes.
Lordship, I am praying for short Passover, Your Lordship.
Where is he?
He is engaged in another court.
Which court?
Maybe court number in 36 or 37.
You are his junior.
No, I am the advocate on record, Your Lordship, but I do not have the brief.
Please take the brief. Passover. Please take the. Yes. Please go to the case call the next matter.
66.
Yes.
Lordship, in this matter, I'm led by Mr. Anjana Mahabul. Lordship, I'm paying for 1 days of accommodation. Lordship,
Yes, yes.
1 days of accommodation.
No accommodation, sir. Madam, please start.
Lordship, I don't have a brief. Lordship,
What is your opinion?
Lordship, yeah, over telephone she informed me to make this matter not today. See, just only not today. I'm paying for not today only. That's it.
An accommodation has been paid for on the ground of the learned advocate for the petitioner. Mr. The hearing of the civil division application stands adjourned for the day. Yes, next.
Grateful, Lordship.
7.
But I am for the petitioner,
Yes.
respondent in an appeal. But we had complained before your lordship, my lord. This is regarding escalation of the occupational charges. My lord, but the appeal has now reached a hearing stage. Appellant has already completed their submissions. My lord, kindly only writes a line, my lord, to expedite the appeal. Nothing else.
Yes, go make submissions.
But no, my lord, no direction for specific period is required. Only no specific period is required. It is fixed on.
Unduly putting pressure upon the learned.
My lord, it is already fixed. My lord,
That is why.
I have placed the order before your lordship.
That is why. What is the necessity of further directing?
No. On other side takes numerous adjournments. My next date is 2nd July 2025.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 17 and orders being number 17 and 20 dated January 8, 2025 and February 11, 2025 respectively, both passed by the learned judge in charge 11th bench, City Civil Court at Calcutta in title appeal number 15 of 2024. First of all, after some argument, Mr. Banerjee, learned advocate, appealing for the petitioner, raised that a direction be passed upon the learned judge of the appellate court to dispose of the title appeal number 15 of 2024 expeditiously. So from the order sheets appended to this application, this court finds that 22nd of May 2025 has been fixed for hearing of the appeal. Mr. Banerjee further submits that in the meantime, the appellant / opposite party hearing has already concluded their argument, and 2nd of July 2025 has been fixed for further argument of the respondent. So in view thereof, CO number such and such stands disposed of by requesting the learned judge 11th bench Civil Court at Calcutta to make an endeavor to dispose of title appeal number 15 of 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Deeply obliged.
On the next matter.
68.
Yes.
My lord. But what has happened, my lord, in a partition suit filed by the petitioner plaintiff here in my lord, before the learned Jorhat court in Assam, it was discovered in a written statement filed by the defendant, the opposite party herein, that a general power of attorney has been relied on, dated 1983. No impugned order, my lord. In 1983 was relied, and thereafter the genuinity of the power of attorney has been challenged in a suit filed by the plaintiff petitioner itself in Alipur. Title suit 1771 of 2022. Now, my lord, after filing of the suit, no date has been assigned, no order has been passed, and order 7 rule 11 application has been filed by the opposite party, and we have filed an objection to the said application, but the same has not been taken up for hearing till date. Now, my lord, on page number 20, my lord, kindly see page number 20. An order has been passed in the suit in Assam on 29th May 2025 by my instance, that unless
There is
the
an order sheet here.
No, my lord, no order sheet here. No order has been passed in the suit
From 2022.
from 2022. Now, my lord, kindly see page 21. In the suit before the Assam court, it has been directed that unless the title suit 1771 of 2022
Under Article 227 of the Constitution of
I will not be able to conclude, your lordship.
Then start. Let me see whether you can conclude or not.
All right, your lordship. If your lordship kindly comes to the 7-1 application, your lordship,
Yes.
that is at page number 23.
You are the advocate on record.
Yes.
All right. I am giving time on your ground, but tomorrow you have to argue. It goes to the brief. The learned advocate. All right.
Gratefully, lordship.
Just call the next matter.
69. I am for the landlord petitioner, my lord, file an eviction suit in the year 2019, my lord. My expeditious hearing, my lord. Defendant has filed, my lord, the 7-2 application is still pending since 2023, my lord.
This application under Article
Time for the Expeditious hearing of this case. Two cross filed in 2008. 2016, my lord, expert degree was passed. Subsequently, my lord, I
This
filed.
case is the order 9/13.
Yes.
What is the stage of the missed case?
Well, next date has been fixed on, my lord, 19th July.
For hearing.
19th of July. But earlier I filed an application for early hearing of the application that was rejected.
This application under Article 220. appeal matter.
Not receiving the post. They are not acting by us. It's my client interest. And your lordship is not also reporting the data.
All right. তাহলে ওটাকে পাঠিয়ে দিই order on the next matter.
71, my lord, I am on behalf of the petitioner, my lord. The opposite party has filed an instant title suit. It is an expeditious case, suit, my lord. And I am the financer over here. They have filed an application under Order 39, Rule 1 and 2. They have an interim order over the vehicle. I have filed 5 and 8 application under Section 5 and 8 of Arbitration and Conciliation Act on 15/7/24. Till it has not been heard, my lord. The whole suit is based upon the 5 and 8 hearing because the agreement has a clause for arbitration.
27 of is same.
Twenty-two.
72 years.
My application for leave to proceed with the suit has been rejected. I purchased the property. Leave to proceed with the order 22 rule 10.
Order 22 rule 10 has been rejected. Rejected, appellable order.
No. Order 22 rule 10, my lord, if you logically consider order 22 rule 4, 9 and 10.
Order 22 rule 10 either way appellable.
But the application was filed under order rule 10 for addition of party also. So order 20, it proceeds with order 22 rule 10.
Mr. Rai, if it is devolution of interest during the pendency of the suit.
By way of purchase.
Whatever. Yes, so devolution of interest by
Yes.
purchase. It is order 22 rule 10. Even if you caption it as 151 or order 1 rule 10, it is order 22 rule 10 appeal.
Now one can once, my lord.
Mr. Rai, if it is devolution of interest during pendency of the suit, there is a specific provision. You have to caption it as 1 under order 22 rule 10. So the provisions of appeal stand attracted. Yes, Mr. Rai.
The order 22 rule 10 has been rejected.
Yes, yes. And if it is devolution of interest during the pendency of the suit, it has to be captioned as 1.
Order 22 rule 10.
By the order.
24.
Yes. Yes.
CPL, suit for declaration and permanent injunction. One deed exhibited the defendant number 1 in the year 22, 12 and 22 lawsuit. These documents is the fraud documents. The documents is not.
What do you want? What is your prayer?
My prayer is the Lordship 151 petition for the non-exhibited the documents of the.
It has been exhibited.
Expand
Where
the document.
is the provision to expunge and exhibit once it has been exhibited?
These documents, Lordship, they exhibit.
Show me the provision under the statute which permits expunging of an exhibit.
When does it fix, Lordship?
This application under Article. ঠিক আছে, যেখানে পিটিশন ইউ আর ফর দি অপোজিট পার্টি, যেখানে পিটিশনার সাবমিশন করেছি তারপর yes, next.
75.
On my application,
yes,
but there will be an issue of maintainability, as I believe it will fall from your lordship, because my lord, I have challenged an order of the Learned State Commission in this revisional application passed in its revisional jurisdiction. But I am covered by two recent judgments of the National Commission, where the National Commission is categorically held as late as May 2025 that a revisional petition before the National Commission as against an order passed by the State Commission in the revisional jurisdiction is not maintainable.
Yes.
That is why I am before your lordship.
Yes. What is the order impugned?
The order impugned is of 10th June 2024, whereby my revisional application against the order, ex parte order passed by the district forum was dismissed. I am a landowner in respect of a multi-story real estate project. There is a limitation of liability clause in my development agreement. The developer has failed to hand over possession. I have been made jointly and severally liable as a landowner to refund the consideration money paid to the developer by the first court, the district forum. There is a in between similar parties, there is an order of the West Bengal Real Estate Regulation Authority, where I have been held to be having no liability. That order, your lordship, will find at page 113 of my last brief.
Yes.
Same parties. One of the developer and the landowners are the same. Lordship will see Fairland Development India Limited and my lord Shomita Construction, who are the developers, and Team Taurus is the group company. Your lordship will kindly come to page 116.
Yes.
Third paragraph notes the contention that what the case was for.
Yes.
And on the page 117 is the petitioner, respondent number 1 is the petitioner before your lordship.
It transfers from the records that the respondent number one, Fairland Development India Limited, is the landowner of this project, but nowhere the signature of the landlord is present in the documents.
That is the order of the district forum.
But the order of the district forum, this is the order impugned.
No, that is the, you have said state commission.
State commission, you lord.
That is
The order of the district forum, my lord, is at page 92 of my lord's brief. My lord, I failed to enter appearance, but I raised all this point in my revisional application, which my lord is at page.
How can that be considered in a revision application? Your remedy lies in an appeal.
But the revisional application, my lord, was entertained.
Maybe.
And dismissed on merits.
Maybe.
But rightly or wrongly, my lord, it was dismissed on merits. I understand, my lord, to be candid, my lord,
merits it cannot be.
To be candid, my lord, this is the very question I posed to my client when he came to me. But my lord, kindly sees the judge's order. My lord, today, my lord, I cannot be without a remedy.
You have filed an application, the judge has dismissed that. Show me, but you have ought to have challenged this order before the state commission.
But I challenge this by way of a revisional application that has been dismissed.
The scope is very limited, sir.
I understand, my lord.
So,
but my lord, there is an order which dismisses my application on merits, holding it to be maintained, not holding it to be maintained. Maintainability was not the issue. My lord, kindly sees my revisional application. I have categorically raised all these points.
I am also not saying it's not maintainable, but the scope is very limited.
I understand you, lord.
So, maybe maintainable.
But today, my lord, I
sitting under Article 227, I cannot also go beyond that.
I'll tell you, lord, the predicament I am facing. I went before the National Commission.
Is there no provision for setting aside the ex parte order?
No. That is the difficult.
It's difficult.
But I'm stuck in a procedural quagmire. But if I may use that term, I can serve and come back. That's all.
The petitioner has challenged the order passed by the state commission. The next matter.
76.
Yes.
76, my lord, for the petitioner paying for Passover, my lord. Mr. Misra.
Sir, what is this matter about?
This matter is about the challenging the order of the Honorable DRT, my lord. DRT, my lord.
DRT is not there.
DRT is not functioning right now.
Why?
From tomorrow, there is notification issued by the Honorable DRT court that the Honorable presiding chairperson is not available before this Kolkata DRT, my lord. For this reason.
Of the learned advocate for the petitioner.
Lordship, I am for the petitioner, Lordship.
Yes.
Lordship, Order 39, 1 and 2 has been passed by the learned civil judge, senior division, Bakura, Lordship. And thereafter, I pray for an application under 39, 4, Lordship.
Yes.
Thereafter, on the fixed date for hearing the Order 39, Rule 4, the Honorable Learned Court has pleased to hear the maintainability point, Lordship, Order 14, Rule 2, Lordship. My application under 39, Rule 4 was kept in abeyance, Lordship. Today was the date, Lordship, in the lower court, Lordship. And Lordship, both the application may be heard in the next year before the Learned Court below, Lordship.
If the preliminary issue be decided,
yes, ma'am.
Thereafter, the application
Yes, only one thing that I must point out before your lordship, it's a family matter of Mr. China. Used to be
Since I'm
practiced.
not inclined to take up this matter on
Should I not be anything on that?
your client.
But
What happened, Mr. Banerjee? You are for the other side. Can it not be resolved? Please see to it. Is important. 79. Yes.
my lord, but amendment of plain Miller under order 6 Miller rule 70.
Yes.
Under order 6 Miller rule 17 Miller page 19. Page 19.
217. What happened?
My lord, page 19 years of, can you see the order? Because I have been dispossessed by virtue and encroachment. For the reason, Miller, I made an application. Can you see the order? I have dispossessed. My lord, I recover possession. For the reason, I made an application for amendment.
Where is your application for amendment?
Well, last page. Then what was the next page? Miller? 91. 91. 91.
Yes.
Page 91. That after.
91. Yes.
Next page. What are you doing? This is the application. Next page. Well, I have been dispossessed and by virtue of encroachment by the Pradhan. But there is a party in the suit. I have plaintiff. The suit property that has been decided, but some portion have been encroached. Why virtue of I have been dispossessed. And can I see that portion will not be amended for this side suit. Some portion, because we are road construction road, you also can see the order. And some mistake is there, in the change minutes or
At what stage?
My lord.
At what stage?
But what is the date fixed for the argument?
You are the plaintiff.
My lord, I was the plaintiff.
By the order impugned, the application for amendment.
My lord, may it please your lordship, my lord, I am for the petitioner. This is, my lord, for a
Not Mr. Ratan. Where is Mr. Aradhan Banerjee?
He was here only in the 2 matters back. Oh, Aradhan Banerjee.
Oh. Not only
Yes,
one,
Mr. Ram.
my lord,
My lord, these
I'm being led by Mr. Anindo Mitra, my lord, in this matter.
my lord, I am also led by Mr. Kishore Dutt in the matter. He mentioned the matter, but the urgency is such I have to press it.
Right.
But
Because-
Mr. Nag, it was mentioned in the morning
Yes,
that
Yes,
it,
yes.
may
Yes,
not be
of
taken up, may not be reached
I
today.
was told.
That was being mentioned.
Yes.
That though I have said that it will appear on the day when it is.
My lord, I am
written in the
tendering
list,
apology on
it is
behalf of my
appearing
senior.
way down,
No.
it may not reach in course of this. That was the mentioning at the morning.
Lordship. No, my lord, today I am mentioning, I am moving this matter. My lord, the urgency is that, my lord, before taking, my lord, this is, my lord, against an ad interim order passed by the City Civil Code.
Mr. Nag, what have you included in this?
Because it has a checkered history. My lord, in short, in 2
What is
minutes,
the impugned
my
order?
lord, I tell you, Lordship, I have the right of carriage of person.
Yes, you have the identity from an identity
No,
order. Fixed second.
Well, here the ad interim order is, well, there is mounting due. Well, the total due is 58 crore. As of today, the monthly rent is 64 lakhs. Well, in violation of
What is the order impugned?
order impugned, you can occupy upon payment of 4 lakhs. That is the order. Now, my lord, I tell your lordship, my lord, on earlier occasion, I also, my lord, express my apprehension, my lord, the way it is functioning.
This is the PP appeal.
This is the PP appeal ad
In
interim.
connection with that stay order has been passed
Stay order.
subject to payment of occupation charges.
Yes, occupation.
So you are aggrieved by the quantum of occupation
Quantum
charges.
also on the limitation.
This is the volume of a civil division.
Because I tell this as a checkered history. I tell your lordship, my lord.
No,
My lord, you know,
sure.
it's round, my lord, it won't take much time. my lord.
Hopefully, my lord,
I will wrap it up. I will wrap
No,
it up within 10
you
minutes. my
shouldn't.
lord.
Entire story should be told.
Yeah, of
That's
course.
what I'm saying.
My lord, you can't apprehend that I will suppress something.
No, I'm
Let-
not apprehending anything, Mr. Nath.
So, my lord, first instance, my lord, from the PP proceeding, a case was filed before this honorable court. Now, my lord, as an interim order, an order was passed by this court that till
Nag, are you interested in fighting with the rate of occupation charges, or you are interested in dismissal of?
Here I am, because they, my lord, lordship will see no reason has been assigned.
The other orders frustrated, statute is frustrated. It says 1 month from the date of filing.
Also,
Cannot be done in this way.
also this order, my lord,
Cannot be done in this.
in this order, two things, one statutory provision has been violated, that is 9(3), and my lord, the settled law. I, in the Atmaram's judgment, and also, my lord, I will rely on a unreported judgment of Supreme Court, which say that if you have to occupy, if you have to pay in terms of the SOR, the scale of rate. There is no other way around.
Exactly what you do.
No other way around. Well, the SOR is not 4 lakhs rupees.
In which volume is the impugned order?
First volume, last annexure, lordship takes.
First volume.
Last annexure.
সরিয়ে দিন তো এগুলো খুলুন তো।
May I just tell your lordship in a, well, just a background. Well,
যেটাতে impugned order আছে সেই ভলিউমটা দিন।
well, initially the matter came up before the High Court. Well, the High Court said you have to pay 16 lakhs. That is in 2018. Till the eviction proceeding is over. Now, my lord, sometimes they paid, sometimes they failed. Ultimately, well, he is not the owner. Now he stepped into the shoe of the owner. Now, my lord, the matter went to NCL.
Owner?
Yes.
How can he be the owner?
I got all facts confused.
I tell you, lord, my lord, initially somebody else used to own this flotel. Then, my lord, after this failure, this 14 lakhs also not paid. My lord, 2 grounds of eviction are there. One is encroachment, and second is, my lord, default in payment of rent. And violation of High Court's order, because High Court says that you have to pay 16 lakhs in between. Now, my lord, the matter thereafter went before the NCLT. My lord, went before the NCLT. Now, my lord, in the NCLT, my lord, without hearing me, my lord, a resolution passed.
Give me a minute.
Lordship.
The order is dated 11th of June 2025. Order is dated 11th of June 2025.
Lordship.
Please give me a minute. Please take your seat. Both of you, please take your seat.
Yes.
challenging both the orders that or both the portions of the order,
both
the condonation as well as stay.
both. But for now, for the time being, as interim measure, well, I will just place your lordship two things before your lordship. Kindly come to page 35 of the first volume. Two things I will place.
Mr. Nag, according to you, that you are placing reliance upon a decision, according to you, that it has to be on the basis of the occupation charges has to be paid on the basis of the scale of rates or scale of fees.
I will show.
Show me that point was urged before the learned judge.
I said.
Show me that.
Well, I argued that before.
Show me that. Which portion records
Well,
that?
lordship, page
And
4.
show me the materials produced before the learned judge of the appellate court, wherein you have stated that, look, this is the scale of fees, this rate you have to pay. Show me that.
Lordship, kindly come to page 4, internal page 4 of the order.
Yes.
On the other hand,
yes,
learned advocate general appearing, just leave it, ballot kindly come from with regard to the prayer of ad interim order.
Which page?
Internal page 4, ballot 10 lines from the top of the second paragraph. With regard.
Yes, yes.
With regard to the for the ad interim order of stay of operation of the impugned order passed by the estate officer, it is submission of the advocate general that the outstanding dues of around 58 crores in total to be paid by the appellants and also around 64 lakhs per month to be paid as rent they have ignored to pay. He also submits the counsel for the appellants questioning the authority of present passing such an
show me that schedule of your place. This is your submission 64 lakhs. Where is the basis of that?
Kindly, in the ad interim order, all submission not recorded. Kindly come to page 32 page I will place.
So now show me the basis which you have placed according to you before the learned judge of the appellate.
It is an ad interim ballot. It is an ad.
And I am directing the court below to decide on that.
Kindly have a look at page 35. Two things, ballot. One is High Court order.
Mr. Nag, if you say it's an ad interim order, I am directing the stay application to be finally decided. File your objection. Put all materials. The learned judge will consider that.
They filed an objection on Friday. We have we are supposed to file it tomorrow. The matter is now fixed on the 2nd.
Kindly have.
This is an ad interim order. So, have you filed all your materials? So, I am directing the stay application to be disposed of finally.
Pages, even prima facie when it is stated. Kindly page 36 of the order of the High Court. Lordship sees and I will show their admission. And then Lordship decide if Lordship wants to send me that, I will go happily. Even if they admit that I will pay in terms of the SOR, and it was submitted before the court, I don't know how can the court pass a different order. Kindly have a look at page 36.
So now there are two things.
Just
one is this is an ad interim order.
Correct.
The stay application is pending before the appellate court.
Lordship.
So you can place all materials before the learned appellate court. These materials that they have agreed, everything the court will consider that. What is the next date fixed?
Well, the next date fixed is Wednesday.
This Wednesday. So I'm directing all materials to be considered and to pass an order.
Well, kindly just indicate my
objection. Hear both of you at this ad interim stage. I have to stay that.
Kindly hear as well. We are
there
acceptable.
are two things you have to take
in respect of my instruction is in respect of this quantum of the occupational charges that we want to place before your lordship, because there are 2 pages I just want to show just 2 pages.
Yes.
Kindly come to page 36.
Yes.
Lordship till such time is the order of 2018. How can 4 lakhs, I ask this question to myself. That, till such time, estate officer 36.
Yes, yes.
Till such time, estate officer decide the issue, the petitioner shall be liable to pay occupational charges at the rate of 14,34,954 to the port trust without prejudice to the rights and contention of both the parties. I specifically handed over the order to the learned judge. Now, kindly come to
show me where it records.
It's not recorded. As an officer of court, I can vouch that I handed over personally the order to
the Nag, I cannot decide from here
now,
whether you are placed or not. So you know the procedure.
Now, my lord, it is
the law, the Honorable Supreme Court has decided such issue. If you say that you have placed, the court has not recorded, remedy lies elsewhere.
Lordship. But
so you have to proceed on the basis of the recording. I have to proceed that the records of the learned appellate court is sacrosanct. I have to proceed on that basis. If you say some materials were produced, some submissions were made, not recorded, remedy lies elsewhere.
Well, I know, but my lord, kindly have a look
take
at
that recourse.
also volume.
I don't mind.
Also,
Also, decide. We'll show perhaps
volume,
only
volume
1/10 of the story has been given.
I have not given the story.
Oh, very
I am not given the story. I am just only on the identity.
We are quite happy. Mullah wants to decide the quantum. Or Mullah has fixed on the 2nd of July, but we can also go.
Volume 4.
Mr. Nag, if you want that a decision on this quantum, then it is it is a hotly contested matter. I have to fix a date. I'll fix a date for hearing of this.
Lordship, decided. Decided. My lord, one thing, my lord, page 539, once by not for my satisfaction, volume 4. Volume 4. Well, they have before Supreme Court says that they are agreeable to pay in terms of SOR.
Supreme Court also said go and settle. And Mullah, they came to Mullah evict us. That's why Mullah, Supreme Court passed an order saying that you go back and ask for stay. I've never seen Mullah such a direct order of the Honorable Supreme Court.
Supreme Court say
order was passed while the matter was pending.
539. 539. They are admission.
Schedule of writs.
Yes.
The respondent shall pay the license fee as per the applicable rates SOR from 31st/10/2018 and shall continue to pay such license as per the fees published by the KOPT. So, my moot question before your lordship is this. How can, if they, first is they cannot go beyond the High Court order, and second, the SOR.
Instructions, what we have been paying.
I will have to decide this.
Lordship, fix the matter.
Ashwin.
My lord, I tell your lordship, my lord, I am challenging.
Otherwise you cannot evict them.
My lord, I am challenging the section 5 as well condonation of
Section
delay
5 देखिए तो।
as well as my lord, the quantum of damage. Both I am challenging. So my lord, the appeal cannot proceed, my lord. Appeal cannot proceed.
11 days, my lord, because
There also has to be, there has to be also a stay.
yes, my lord, kindly, my lord.
Considering the fact that
Yes. Well, lower court proceeding has been stayed, my lord, by lordship's order.
stay of the
Appeal,
stay of the order of the
appeal, my lord.
estate officer has been stayed.
Well, the appeal has to be stayed also, my lord.
There shall be also an order of stay of operation. Sir,
81. My lord, on behalf of the petitioner, I'm praying for a short Passover, my
no
lord.
short Passover.
Well, then kindly make it not today, my lord.
Yes, yes.
Kindly make it not today, my lord. Kindly, my lord.
Not today. Yes, call the fixed
Much
matters. Yes.
PM matters, monthly list. Thirty-nine.
Well, I am appealing for the petitioner, my lord, for 39. The petitioner is the plaintiff before your lordship.
Yes.
Has filed the suit for eviction in the year 19, in the 2019.
Yes.
Suit for eviction was filed in the year 2019. On 20th January 2020, ex-party order was fixed. Argument was concluded. Thereafter, the defendant appears. Initially, they appear and sought for time. Thereafter, they did not appear. And after the argument is over, defendant appeared. The Landlord trial court allowed him to file written statement subject to payment of cost of rupees 2,000. But till date, they have not filed any cost today.
If the cost has not been paid, so this order stands.
Well, after a period of 5 years almost. Well, kindly, argument is over. Well, kindly come to page, internal page 3 of the certified copy. First order 16/1/2020. Plaintiff files Hajira. Defendant files a petition praying for time. On call, none appears on behalf of the
After the argument, show me when the arguments were made.
My lord, kindly. Last but one.
By the order impugned, the
547.
547, I am appearing for the applicant, my lord. This is an application for expeditious disposal of an interlocutory application, praying for modification of an ex parte order passed by the Honorable NCLT. But the application has been filed in the year 2021. It is still pending disposal. Lord, I have prayed for the modification of an ex parte order freezing all my bank accounts. So that is pending hearing. Pleadings are complete, my lord, on one pretext or the other. Because of paucity of time, the matter is not being taken up and it is being adjourned date to date. The next date has been fixed by the tribunal on 17th of July. And on the last two dates also, my lord, kindly sees, my lord, the matter has not been.
Where is their application? What is the
My lord, the application is at page, my lord, 23 onwards. My application for modification of the order, ex parte order.
this application under Article 220?
Lord, I appear on behalf of the petitioner, my lord, by the impugned order, my lord, my application for analogous hearing of both the suits, lord, has been rejected, my lord. Lord, both the suits have been filed by me. Lord, the first suit is for the eviction of the trespasser.
Both the suits are filed by you.
Yes, my lord. And
What are the stages of both the suits?
my lord, on one suit is at cross-examination, tendering of PW, and the other, my lord, is for issues.
What are the two suits for?
My lord, first suit is for eviction of trespasser, and my lord, second suit is a declaratory suit, my lord, that my another partner has subleased the property by way of a registered deed of sublease. Lord, I am
That
praying
is a
for
different thing. Issues are different.
yes, my lord,
So
but
how can
but
the
my lord, on the practical view, my lord, both the my lord, in both the suits, what I am going to mark exhibit my documents,
No,
my lord,
no, no.
both the documents will
There are
be saved.
procedures for that. For that, the both the suits cannot be heard analogously.
My lord, the documents which are to be relied on are similar of nature, my lord.
Maybe. Where are the plaint?
Plaint
One
is,
is
my
page
lord.
17.
Yes, my lord, that is the first suit.
This is the suit for eviction of a trespasser.
Trespasser, yes, my lord.
What is the next suit?
Next suit is at page 59, my lord, annexed at D. Prayers are at, my lord, page 70 onwards. Prayer.
This application on Ashun, this matter was
My lord, I appear on behalf of the plaintiff petitioners.
Yes.
This application is for expeditious disposal of applications for impounding and agreement for
Application
sale.
for?
Expeditious disposal.
Application for?
For impounding sale agreement which is unregistered. This is a suit for specific performance of a contract. The applications were made way back in
Where is
2017.
that application?
My lord, it's not been annexed with the revision.
When it was filed?
2017, and thereafter two other applications were also filed on 15 June 2023 and 25th April 2024.
What are the applications?
For impounding the agreement to
Hmm.
send it to the collector.
Impounding you have filed on 15th of June 2023. It has been fixed now. It has been fixed when?
21st August 2025.
This application under Article 227.
Thank you.
1408.
One four. Yes, you are appearing. No. This application. This application was mentioned by the learned advocate for the.
One 1473.
Yes. Your Lordship, eviction and recovery of khas possession. In the last occasion, Your Lordship asked me regarding the eviction limitation period for eviction in the Mother Act 1956. Yes. What is the order impugned? Order impugned is mixed question of law and fact. What is the order impugned? Mixed question of law and fact. That is why rejection of the application of Order 7 Rule 11D. But evidence, without evidence, that cannot be looked into.
What is the suit for?
Suit for eviction and recovery of khas possession. Eviction substantive relief and recovery of khas possession is a consequential.
Where is your application under Order 7 Rule 11?
Page 66, Your Lordship. 67, 66.
Yes.
Yes, so eviction is a substantive relief, Your Lordship, and in the last occasion, Your Lordship asked me regarding 56 limitation provisions needs to be referred to regarding 56 Act. Your Lordship, in this book, it has been referred to 1908 Act, Your Lordship.
Sir, what is the suit for? What is the nature of the suit?
Eviction and recovery of khas possession.
Under which act it has been filed?
711D and
suit filed under the provisions of which act?
1956.
Princess
Tenancy
Act,
Act.
1956. Yes.
That has to be referred to, Your Lordship, as per.
And according to you, that suit is barred by limitation.
Barred by limitation.
Yes. Where is
Section 39 of the 56 Act, subject to the provisions of this in this Act relating to limitation, all the provisions of Indian Limitation Act 1908 shall apply to suits, appeals, and proceedings under this Act.
Yes.
And Your Lordship, 1963 Act wants, Your Lordship, Section 30. Section 30 of 1963 Act. Your Lordship, any suit for which the limitation is shorter than the period of limitation.
What is the period of limitation according to you for filing this suit?
3 years, Your Lordship. Because eviction is a substantive.
Under which article?
Article not given, Your Lordship. That's why I have relied upon Article 58 and Article 113. On both, I am going to argue, Your Lordship. And for where limitation period is shorter, Your Lordship, I have to rely on Article 1963 Act. First, once, Your Lordship,
yes.
This had been, Your Lordship, page number 55 once. And Article 110 of the old Act. Article 110 of the old Act.
Old Act means?
Old 1908 Act.
Why are you going to 1908 Act?
Because of 1956, I have to refer to 1908 Act. But where the period has been lessened in the subsequent Act, Your Lordship, I have to refer to 1963, provided the suit has been filed after there has been a grace period of 7 years given.
What is the starting point of limitation?
Your Lordship, page that is para 3 of the plaint, Your Lordship, page number.
No, as per the
1984, August. 2nd August, first day should not be reckoned.
What happened on that date?
Your Lordship, the predecessor in interest or the defendants are habitual defaulter in payment of monthly rent, and despite repeated requests failed and neglected to pay the rent for the suit property to the plaintiff since the month of August 1984. 2nd August 1984 to 1987, 1st August. And Your Lordship, in page 55, I was directed to pay arrears, where arrears after 3 years is barred. To pay arrears up to from 1984 to 2006. That is one. Article 110 of the old Act I have to, because all the 3 years, both are same.
So beyond 3 years, the
area range cannot be claimed.
That cannot be claimed.
Yes, next.
Next, I'm coming, Your Lordship. Next, the bunch, Your Lordship, starting with Malvia, this one. And Your Lordship, one more important. Lordship, one.
Sir, be fast. Motion stage,
Your Lordship, one.
not the hearing stage.
Your Lordship, Your Lordship. And this letter, Your Lordship,
Sir, I cannot go to those.
Go to merits. Okay, okay. Your Lordship. Para 37. In the last day also, last occasion also, I did
Para 37 of?
37 of Mallava and another appellant versus Kalsa Manavara Kalam.
Judgment.
Yes, Your Lordship.
Yes.
Para 37.
Paragraph 37.
Which I have relied on, Your Lordship, regarding this substantive relief and consequential relief part. Consequential is possession because after 6 months, I have to file for declaration first. And then I have to.
Sir, did you file any application under section 17(1) and 2?
No.
You did not file?
No, no.
Your defense has been struck off.
But I
Your
couldn't.
defense has been struck off.
My defense, no. Not struck off, but due to mixed question of law and fact. But
no. 17(2).
17(2) of. Yes, 17(2), yes. Oh, there for our 1956.
Please come to that order.
That order is article page number. That order I had to that one 55 I did refer to, Your Lordship. After 18 years I had to pay all the rent including arrears and, Your Lordship, and that is why the letter I am referring to, because the beneficiaries strictly through their advocate did write us a letter not to pay rent to anybody. Otherwise I have to pay rent again with arrears and interest to them, because they against Your Lordship, trust property was transferred to the beneficiaries, Your Lordship, and after the lease deed signed, Your Lordship.
Did you challenge this order under section 7(2), which was passed on
7(2) not challenge, but article 52, this part. I am only coming to the provisions of limitations.
Have you complied with this order under section 7(2)?
Without prejudice to rights and contentions. Without prejudice. That is why, Your Lordship, this part.
Yes.
Without prejudice, this part.
All right, yes.
And, Your Lordship, the later, most important part. I was given not to pay rent. The original beneficiaries, those who are. They were never made a party, Your Lordship. They are not being heard. In absence of them, that's a matter of government property maybe. But
what are you showing?
Your Lordship, next.
What is this?
This is the letter written by them. The beneficiaries, Your Lordship, not to pay rent till we get.
I cannot look into this.
Okay, okay.
17.
And without prejudice, and the rent receipt without prejudice to rights and contentions, Your Lordship.
Thank you. So according to you, this should have been filed within
3 years, 6 years, 12 years, all are applicable in my case. But I am pressing on 3 years, Your Lordship, first. And recovery of khas possession is against the landlord, but we have denied them as the landlord, Your Lordship, from the beginning, Your Lordship. Para 37 of the judgment, Your Lordship. Again, I am repeating, Your Lordship. In such circumstances, refer to the above, the court held that if a composite relief is filed for cancellation of sale deed as well as for recovery of khas possession, the limitation period should be considered with respect to the substantive relief of cancellation of sale deed, which is eviction here.
This is not a suit for cancellation of sale deed. Please don't refer to any decision which is not subject.
Only.
Please show me a decision on the suit under West Bengal Premises Tenancy Act which says that this is a 3-year period.
But Your Lordship, that has to be referred to Limitation Act. All the rules has been given as per Limitation Act, Your Lordship. Only Limitation Act. The next time, okay, but I'm not going to. Only for the substantive part. This is a substantive.
Sir, your application is at page 66. Please restrict your submission only to the points raised there.
Page?
Please don't. 66. the application. Please don't enlarge the scope of this.
Okay. Your Lordship, next from page para 17. Para 17 of Rajiv Gupta. Para 17 of Rajiv Gupta, the next judgment. Because Article 58 of the new Act, Article 113, Article 52 is involved. All are involved, Your Lordship. Cancellation of sale deed only for the substantive part. Substantive here eviction, not cancellation but eviction, but substantive.
You serve upon the other side. Have you served upon the other side?
No, Your Lordship, without your deduction, I cannot.
Learned
I'm grateful. Grateful, Your Lordship. Obliged.
Yes.
Happy.
Yes. The application was
জাজমেন্ট গুলো রয়ে গেল কিন্তু জাজমেন্ট গুলো রইল
this matter was mentioned by the learned
Five.
Yes. This matter was mentioned citing Article
Eight. I'm really sorry. On the last occasion, I was present. I thought probably matter will not be called on. But why not called on the matter? I left. As usual. Now, my lord, good senses has prevailed. They have agreed. No problem. All arrangement to be made. Now in High Court Para, what is called High Court Para, there are several chambers, my lord, well furnished. Since one chamber is available, so many chambers are available on the ground floor. And he has agreed to that, my lord.
Ground floor, there is no difficulty. Even if it
floor, make an arrangement. Mr. Manager, do one thing then. Please see where it can be. What is the next step fixed?
there has been a stay of the proceedings. So the
Stayed. I've got stay from your lordship, my lord. So is my suit.
No, can you? Which room will be available in the ground floor? If you make that arrangement, I can specify that. Otherwise, there will be
Friday.
Saying that yes, that is not available, that cannot be arranged. So if both of you can make an arrangement, a specific place where it can be done, consensus, so I will direct that.
So lawsuit kindly, তুই তাহলে এটা দেখ যদি ground floor হয়ে যায় এখানে। তোর তো অনেক কানেকশন আছে। তোরও আছে জায়গা যাচ্ছে বুঝি জায়গাটা
Lordship will keep it on tomorrow, Malad, anytime we'll come back. একটা suggest
জায়গাটা বলো তুমি যাচ্ছে কথা তো শুনতে হবে জায়গাটা
Yes.
গ্রাউন্ড ফ্লোরে
Ground floor.
ও ঠিক আছে
Malad, that place is good, Malad, as well.
আর গ্রাউন্ড ফ্লোর আর গিনোলিয়া কোম্পানি
It's on the church lane.
Is the office of any of the advocates of any of the parties?
No.
Separately.
Certainly, I'll never advise.
That is why.
As my lord knows me, I not do that.
So there, your client is agreeable.
Yes, Malad, any place, if it's a ground floor, no difficulty, and Arginodia, Malad, I know I've been there, Malad, it's on the ground floor.
And my lord, I request the concern যাতে কষ্ট একটু কম হয় তোরা তো দিবি তো কষ্ট তোরা বেয়ার করবি
That cost, Malad, I don't have any instruction. Malad, I'll
you'll have to take you'll have to
have
pay
to bear.
because you ask for commission you'll have to pay তাই নিয়ম that is the law
Malad, we shall bear. Malad, that's the order.
হ্যাঁ অনেক তো মক্কেল but one indulgence I'm taking my lord thrice there's a directions from your lordships to dispose of the matter within 4 months 5 months 6 months kindly give a specific direction within such time and whatever chief they will file the chief within 7 days will take only 2 days or 1 days from the date of the order will take only 1 or 2 days for consideration matters
3 days we will complete the process and within 3 months our trial.
This application word direction. Make a request to the arbiter.
No, it's all right. I know. Only thing is the cost, there should be at the cost. Can you record it, my lord?
That's already there in the order.
Oh, that's
there in the order.
Venue cost. Venue cost.
Everything. Oh, venue cost.
Very bad.
It is however made clear
But
that
boring Chetan, don't be over smart and over excited.
the opposite party shall bear the cost of
Yes.
the venue in addition to the
That's true.
directions, in addition to the cost as directed to be borne.
May I leave, my lord?
Yes, yes. Yes, call the next matter.
1667.
None appears for the petitioner at that time.
I'm the husband. When her husband preferred the mat suit
What is
on
the stage of the suit?
but at present, the petitioner, he filed an application under Order 6, Rule 17. Well, this is pending. Well, Section 24 application has already been disposed of. The husband is regularly paying, every month he is paying rupees 10,000 for the.
What happened on the order 6 rule 17?
Well, it is.
Pending.
Yes, yes. Well,
Application under Article 227 of the Constitution. This is.
My lord, I am for the
Not
Milord.
that as-
Some, my lord, some piece. My lord,
My lord, I am for the petitioners. My lord, during pendency of the suit, plaintiff died. Now he has been substituted by order number 59 ISO lawsuits to see page 11. He has been substituted by order number 59 dated 1st April 2023. And the suit has been decreed in favor of a dead person. Degree has been drawn up against the dead persons. That's why we have filed an application for modification of the degree. But the court disallowed this, hence the appeal is pending.
Rightly. Cannot be done in that way.
Modification of the degree. Order number 78. In the court below the proceedings, the substitution has been allowed by order number 59.
Sir, how this can be done? Plaintiff number 1 died on 1st of December 2022 and the substitution application was allowed on 8th of March 2022.
No.
How can it be done?
This is typographical. First, you will also scan to see page 11 of my revision action. First, page 11, my lord.
Page 11, yes.
By order number 59 dated 1st April 2020, it has been allowed.
Order number?
59 dated 1st April 2023. Page number 11.
By the order impugned.
That whether the appeal will lie or acceptance of commissioner's report.
Yes.
I'll come back next. There's no urgency to that effect, my lord.
Not today, next. Just call the next.
Tomorrow it will be taken up. Tomorrow taken up. Then I'll move.
Tomorrow. Yes, next.
I don't want to disturb your lordship because conflicting.
Opposite party.
Manju might be that. Well, the rejection of amendment application, I have come before your lordship. My lord, the subject matter of the order is that subject matter of the
So urgent, you cannot wait till tomorrow.
yes, madam.
Yes.
At some time. At some time.
Next, call the next matter.
P93. But the can you take up tomorrow? Your lordship summoned the state because the lordship wanted to see the stand of the state in this matter. You have given a notice. Possibly they are not appearing also. We shall give a notice.
I am for the opposite party.
In execution, I am the requiring body. execution award was against me, not the state. The executing court has said since state is not paying, directed the managing director of SBSTC to pay.
You are for the state.
I'm for the SBSTC, my lord.
For the state.
We have given a notice.
Last time the lordship directed them to serve a notice upon the.
We have served a
For
notice.
the state, Mr. Banerjee.
Mr. Nilotpal
You are
Chatterjee.
appearing for the state also.
Mr. Nilotpal Chatterjee.
Asserted who has.
Mr. Nilotpal Chatterjee.
He can play.
I'm-
My learned
No,
friend can
no,
play
I
the
can-
dual role.
No, no, no.
My learned friend can play the dual role.
He got it.
Tomorrow.
Tomorrow.
Lordship, let it retain its position. I mean, 3 p.m.
Lord, I appear for the state response. Lord, am I audible, my lord?
Passover matters.
Nilotpal. উঠে যাচ্ছে।
Order.
Lord, I appear for the respondent, my lord.
আচ্ছা দেবরাজ এই তো আছে
কালকে না।